Good afternoon, and thank you for joining us for the Education Insights Legal Update webcast. This is our first episode of the new season. I'm Keith Bray, General Counsel at CSBA and Director of the Education Legal Alliance. In this series, we bring you top attorneys in the state to weigh in on issues you could be facing at your district or county office of education. Today, we're discussing collective bargaining and the local control funding formula, also known as the LCFF. If you can't stay with us for the full hour, we'll have the recorded webcast available on our homepage by Friday at www.csba.org. We'll be taking questions throughout this broadcast, so please type your questions in the Q&A area to the right of your viewing screen. I'd like now to introduce our three panelists. First, I'd like to introduce Karen Resendiz. Welcome, Karen. Karen is an assistant managing partner at Lozano Smith. Her legal areas of expertise include student issues, labor negotiations, employment law, and general school law. She also advises administrators, personnel commission members, and board members about implementing best practices and encouraging positive labor relations. Karen is an interest-based bargaining presenter and an IBB trainer of trainers. Previously, Karen was also a school administrator, hearing officer, and has served as a pro tem Superior Court judge. Also joining us today is John Pearl. Welcome, John.
Good morning.
John is a shareholder at Dennis, Walliver & Kelly. He counsels public school and community college districts in all aspects of labor relations. He advises and assists his clients in employment matters such as certificated and classified labor contract negotiation, and is a well-known trainer in sexual harassment prevention and documentation. He frequently presents at Dennis, Walliver & Kelly seminars and at other state and regional conferences on topics ranging from collective bargaining to ethical negotiations. John recently worked with me and Josh Daniels on a legal guidance that will be released later next week on grade span adjustment funding. Thanks, John, for that, and we are glad you're here.
Thank you.
Last but not least is Namita Brown. Welcome, Namita.
Thank you, Keith.
Namita is a partner at the Oakland office of Fagan, Friedman, and Fulfrost. A recognized expert on collective bargaining, she negotiates school districts' collective bargaining agreements throughout California. Because of her well-known expertise, Namita is a sought-after counselor and speaker on negotiation topics. She is also the co-creator of the successful AXA workshop, Logged On, which provides education leaders current information on social media and cyber behavior. Namita and Karen joined us last season to discuss the LCAP and the LCFF. If you'd like to hear what Namita and Karen had to say on last season's episode, visit our archive webcast webpage. We're glad to have both of you back.
Thank you.
Well, this morning, I'm very excited to be here today to discuss with three attorneys who have spent hundreds of hours in the trenches negotiating their agreements, collective bargaining agreements with their respective school district clients, and meeting with school board members, obtaining authority and going in and having those difficult conversations at times regarding a tentative agreement approvals. And so we're fortunate today to have three attorneys that have been able to really break through some of the issues that have been before school districts and county offices of education with respect to the implementation of the LCFF. So my job this morning is to get out of the way of their conversation, and I'd like to start by throwing out to all three of our panel members the question, how is this year going to be different than last year with respect to bargaining the LCFF?
I think with the first year's experience in the rearview mirror, I think there will be greater opportunity for individuals to have an understanding of what the LCAP process means and what engagement means. So those who may be held back because of a lack of understanding are going to move forward, and they're going to want a more important seat at the table. Mm-hmm. And those who were involved are going to want to see the fruits of their labor. They're going to want to see that the goals and actions that were included in the plan are actually being implemented and implemented effectively for student achievement.
Well, I think the interesting thing is last year was year one. We were also battling the perception that we have more money under the LCFF. Now we are getting closer to the years where the districts will be getting more money. And so you are going to have not just well-educated people at the table from a perspective of how LCFF funding is going to actually impact our schools, but you're going to have well-educated people who understand the calculations, who understand what it is like to negotiate, not just on the money piece, but on the curriculum piece, because this was the year where they, for the first time, experienced parents and community members sitting at the table talking about programmatic issues that they have faced, that they want implemented at schools. I think it's also going to be interesting because you have groups of parents who represent not just English language learners and socioeconomically disadvantaged children, but you also have other groups of parents like special education who want a seat at the LCFF table. You know, there is the Special Education Task Force, the statewide task force that is coming out with their own requests as part of the long-term strategy of how special education ought to be implemented at school districts. So there are more people at the table, and it's going to be more fought out.
I think in theory, there's a lot that's different with this year as opposed to last year. There's a lot more information we have as a result of the LCAP, but I'm not sure that we're going to appreciate or really see a difference as far as in practice what's happening at the table. I do think it's going to continue to be about money because either there's a perception or the reality that there is more money, but there's an opportunity to understand a lot better what the priorities of the district, what the board are, thanks to LCAP, and those tables that want to share and get involved in the data and information will have that opportunity. But whether it actually, in a practical and real sense, changes the quality and tenor of negotiations, that's left to be seen. And so far, I'm not dramatic. I don't see an appreciable difference yet.
So going back to your statement, I mean, to have, and all three of you have noted the other stakeholders that are involved in the developing the LCAP. Do you see that now coming into negotiations with our labor representatives? Has there been a reaction to that?
There has. I mean, I appreciate what John is saying to an extent, but the reality for me at my tables is that you have labor groups bringing in the same issues around compensation and benefits and the length of professional workday, but it is now presented as a proposal to the district in terms of the district's LCAP priorities. So it's not just saying, you know, we want more money. It's about we are now doing X, Y, and Z to meet the district's expectations as outlined in the LCAP, and as part of that, our workday is impacted, and because of that, we want you know, more money, or we want additional stipends. So I agree that the issues fundamentally are going to be same, but there is a different way that data that LCAP has sort of put in place is being presented at the table.
Well, and I very much agree, because I think
it's
that
good that you're agreeing with me.
and I tried to. But when it comes to the LCAP, both sides, it allows the board and their team to articulate what their priorities, what their goals are, what their actions should be at the table. And we've been preaching for years that when it comes to working with the board, when it comes to preparing your bargaining team, we want to identify what we stand for at the table, what our goals are in these negotiations. And I think the LCAP gives us those core values, those anchors, those kinds of things that allow the district team to articulate very well what they're trying to achieve in negotiations. And if that has the effect of changing or enhancing the way the unions are actually making their proposals, then that is very much a win-win. I think as we get better, as we evolve, I think that quality of bargaining is going to improve.
Have you, Karen, found that the conversations that you're having with your board members to start the year on your initial proposals, have you found that changed a bit with the LCAP and the LCFF?
Surprisingly, yes. I think it's the good news is that, and just to put it in context, really it's been over the last 8 weeks that negotiations has started up again for most of the districts that I work with. And in the advance preparing for the negotiations, there's been more conversation about intervention programs. What are the impacts of intervention programs on wages, hours, working conditions? What aspects of the LCAP may be negotiable? What aspects of the LCAP are really going to be the responsibilities of the teachers and the classified staff that are involved in the schools. So that's been a good conversation. Things have come up like secondary class size and how do we go from a secondary traditional schedule to a secondary block schedule so that we have more options for AP and IB classes, more access to A through G requirements. And that's translated into negotiations at the table with the bargaining units. I've spent more time with some of our big districts than I have in the past, district bargaining units, talking about, is this program, is this intervention going to make a meaningful difference for students as a whole and the students that are targeted. And it's been great, actually.
Have any of you found that the composition of our bargaining teams have changed any in terms of what resources and the type of staff or personnel that needs to be on those teams now?
Well, both the district team and the union teams have changed a little bit. I'm sure they'll continue to evolve. In terms of the district teams, those in the curriculum areas, maybe we've had a few principals or assistant soups in attendance, but now individuals from educational services and the curriculum departments are involved in the negotiations, preparation, and at the table, because there are a lot of questions about what does it look like to implement LCAP.
Have you found that too?
Yeah, a lot of not just curriculum folks, but also technology. You know, with the SBAC testing, with the idea that I have more and more districts that are looking at blended learning and what that looks like in the classroom. Teacher workday, how is that going to look like for a teacher workday? So you have curriculum folks, you have technology folks at the table, and in many places, the superintendent is coming in because the superintendent wants to set the tone. It depends on the size of the table. You know, I'm not talking about large urban districts, but in smaller districts where the community is tight-knit, where there is a lot of talk about education reform, there is a pushback on Common Core, you have the education leader of the district stepping in and saying, look, let's put all those political differences aside. What we are going to talk about is student learning and how do we achieve that. So.
And then also on the union side, I think you're seeing a more inclusion or making sure that all of the different grade levels are actually covered, so that you have the elementary perspective, the middle school perspective, the high school perspective. And I think as far as our teams on the district side, predating LCFF and LCAP, I think we've seen a positive expansion to make sure we have people from the sites represented and included, because their perspective is significantly different than someone who is just necessarily in the district office. So these are very positive.
So Karen mentioned the timing of negotiations this year. We're in our second year. We led off today with, how's this year going to be different? But talk a little bit about the timing of negotiations here in our second year of the LCFF. When if you looked out through this school year, when do you think a good time to start bargaining actually is?
I think there's a lot of planning going on right now. I think most tables are just sort of starting for 14-15. Some have already reached deals and have been able to wrap things up. But I think it's going to be all over the place. I think there will be some that start earlier, some that will wait until we have more information, until maybe some things are more sure with the budget, even though I think we have greater certainty this year than we've had in years past. But I think you're going to see a mixed bag of when teams start, and I don't think there is a wrong approach or a right approach. I think it's going to depend on each particular district, what their history is, how lofty their goals are as far as what they're trying to achieve in negotiations, and it'll vary from district to district.
And what about the data piece? In terms of last year, we did our first LCAP, and this year we're working our way through. You were talking about the goals and objectives. What about that data piece? When do you anticipate some of the metrics to have been completed and the information that we've received? Is that going to have an impact on bargaining at all, do you think?
I think absolutely. You do have districts that had some data collection that was occurring even prior to the first LCAP being finalized. I think the issue at bargaining tables is going to be not how data is used, but what elements of data that are used. Because I think there is this automatic propensity to say, well, that's not a great measure of this particular metric. This is a better way to measure this particular piece that you're trying to measure. So I think districts and unions have to get used to the culture of data collection, of what is appropriate data collection, and we have to agree on what is the right data to look at when you're talking about student achievement. It can't just be, test results or how SBAC testing is going to turn out later in the year. So data is always going to be present. It always was present. I think it just takes it to a new, different level where we are going to have more finite strands of data available.
And that's really the great opportunity, I think, for LCAP, because there are a number of tables, whether we had the data or not, but they didn't use the data. And it was a different kind of bargaining. And now with LCAP, with all of the information that we have, and with the obligation to be checking those metrics and seeing how we're doing and test whether we've actually made improvements and changes consistent with the LCAP, data is going to become a much bigger part of negotiations, and that's the way it should be. It should be a driving force in quality negotiations.
I think because of the 8 state priorities that include student outcomes, there's the baseline data that they've been collecting to do their LCAPs. Those are measures that we're going to be obligated to live by, and it then becomes a standard in negotiations that'll be evaluated as we go through this process. I think this is year 1 of the LCAP. I think we'll know a lot more in years 2 and 3, but it's going to continue to be given greater emphasis.
You mentioned that there even are some districts that have already reached an agreement. And one of the surprises that I had last year about the bargaining that took place is there were multi-year deals that did take place. Can you reflect on that a little bit in terms of where in districts it was more likely to occur than not in terms of a multi-year deal?
Well, in one of the districts that I worked with last year where we achieved a 3-year agreement, 3-year closed contract completely, I think in that particular district, just to use it as an example, once that was done, there became a greater understanding of what the LCAP process was and the differences it was going to make in terms of programs and actions and services for the district. So there was a little bit of regret, not on the economic side, because I think it ended up being a great deal for both parties, but on the participation in supporting the interventions that were going to be in the LCAP. So there was some disappointment in that. On the other hand, because they have a closed agreement for 3 years, they can really focus on educational goals and objectives rather than spending as much time as they were at the table. So now the responsibility of the district, the board and the administration is to really make collaboration their new normal and bring people in regardless of negotiations. That's only one point of contact. It's important that our bargaining partners be part of everything that we do that supports.
Now that's a great point. I remember the multi-year deals. It gives you the off years in which you work on relationship, you work on your programs. How about you two in terms of the multi-year?
I have some that have reached deals, but I don't have very many closed contracts for 3 years. And the issues are, it depends on the nature of the district, right? So if you are a district that had many furlough days, you're talking about restoration of programs. And so, you want to give the board an opportunity to weigh in on that rather than locking in the board right in year 1 as to what the next 3 years worth of priorities are going to be. So I have many districts that are looking at closed contracts in all the language areas, but they are looking to open on compensation and health benefits. There are districts that have agreed to a baseline number for years 2 and 3. And beyond that, they would come back to the table and negotiate just to talk about labor peace. But I think overall, the sense is that there is money to be given, and we'll come back and prioritize where our educational priorities are and where our employee priorities are, and we're going to make the division between that.
And think about where we've come from, where we were in the Great Recession, and it was actually the district that wanted to open up the contract every year because we didn't know what we would need. And there were a number of units, whether they be certificated or classified, that wanted to see if they could close the contract for more than 1 year. Now, sort of on the precipice, or sort of this first year with the LCAP, it's very much a changing dynamic. I have very few closed contracts for 3 years entirely, and that's very much because I think both sides want to see how things evolve and what changes will be necessary. But if we can limit those discussions and then do things away from the bargaining table, I think that's in both parties' interests.
Well, you both began to really open up an area of discussion that we'll have today with respect to the funding sources. But give me your idea about, in this new era of unduplicated student counts and what they might mean district by district. How are districts responding to that? The old days of comparing to a neighborhood or a neighboring elementary school district like that elementary school district, those days, are those over because of these unduplicated student counts, or are you still finding the districts, in order to get a good handle on really what their agreement should be in terms of looking at their neighboring districts?
Well, I do think that those days of sort of traditional talk about what's a comparable district, those days are over, because that traditional comparable, your neighboring district, can now be entirely different. So now it's looking at different kinds of comps, and actually the fact-finding criteria in the RADA Act, I wonder whether those even apply anymore, and whether they're even relevant, because they speak in a different era when we were dealing with revenue limit, and now it's very much changed. But now, depending on your demographics, how you use the supplemental and concentration grants is going to be very district specific, and it will change.
And I agree with everything John has said, and this will be the only time I'll agree with everything John has said. But the reality also is...
we're on tape.
38 minutes in.
But the reality also is that board members, when they are out in the neighborhood, they are going to be approached by people who are going to talk about what the local school district right next door has done. Sure. And so that level of local geography is still going to be relevant. And what is happening, I think, is that we are doing a good job educating both our district employees, as well as the unions are doing a great job educating their teachers how funding has changed. So even though members of the community are feeling the local neighborhood adjoining district may have given a 10% raise and we're only offering our teachers 7%, people are open to the idea that it's a different paradigm. And so that changes the conversation.
I think this is a particularly difficult year for the compensation negotiations aspect of it. You're talking about comparability, but when you have the impact of STRS coming into play pretty late in the process of preparing your for your following year negotiations, you have that as an issue. I think in anticipation of 2016, when Prop 30 sales tax monies go away and then income tax monies go away from Prop 30, I think it becomes a difficult conversation, and comparability isn't the only issue. In terms of comparability though, even though the old government code fact-finding standards are still there and we're still required to comply with them, the comparability is going to be a much more nuanced analysis. It's going to be, what is the unduplicated count at this district that's in the region compared to this district? They're going to be looking for similarities, and they're going to look at things like, okay, what did they do for their class sizes? What are we going to do for summer school? How are you going to approach collaboration time? How much prep time do elementary teachers in the neighboring district have? So it's going to be nuanced and more a deeper level of analysis when you're looking at comparability.
Keith, even a district that does relatively well under LCFF, another big issue is going to be if they are a declining enrollment district, all of their gains through LCFF can be wiped out or significantly reduced if they have declining enrollment. So it's going to be incumbent, I think, upon each district, each board leading that district, to make sure that we're communicating about where that district finds itself, what the targeted needs are for that community, and using the bully pulpit of the board meeting, of different forums, and making sure that that message is getting out so that not only the bargaining units know what's happening, but also the greater public and all the other stakeholders that are involved.
Have the certificated bargaining units in particular, are they bringing to the table their notion of what the comparisons may be? Or are they searching for their court as well in terms of what to play at the table in terms of comparisons?
Well, in my experience, the comparisons have not changed beyond geography at this point. Right. Unions are still bringing districts that are close to them geographically. and districts usually find themselves in the place where they're saying, well, that's a unified district, we are not. Oh, well, that's a K-8 district, that's a basic 8 district. So we sort of weed our way through it. But that to me is an issue of joint education, that we both, districts and unions, need to work together to get to that place where we understand who our real comparable districts are.
Did any of you had the tables that I heard about that had cut a deal and within days the STRS legislation was passed, and thereby having that incredible increase to the district and county office costs?
In some circumstances, it was even a step before that, or maybe there's an offer on the table.
Okay.
And they've had to come and pull back that offer because circumstances changed. And that's very difficult, and it's hard to work through that. I think, as Namita said, that education process of looking at the data and having a better understanding that while we have to pull back this offer because of our economic circumstances, there is a great benefit to having a pension that is going to be solvent when you're ready to retire, and we understand the importance of investing in teachers and in their retirement. But it makes for very difficult conversations. And for the districts that did enter into agreements prior to that information, I think that the consequence is going to be felt in subsequent years of negotiations.
And I think the STRS, the problem with the STRS piece is it's a huge hit for districts. But it can be just played out as a huge district hit. For teachers, it's a matter of doing business. And so to frame it in the right way that we have to account for. Because if you don't frame the issue right, the risk that you take is the STRS increase being viewed as step and column. It's just what you do. It's just the cost of doing business. So I think there has to be education and communication around how you prioritize it, how do you package it, and how do you present it as an ongoing cost.
The governor and the LCFF was based on the premise of subsidiarity, that there was a level of local control. And jumping to this concept now, after just talking about the Cal STRS increase, where districts were hit the hardest, much more so than the state, picking up their fair share, or employees. On the ballot this November is Proposition 2, which is the rainy day fund, but now attached to the passage of Proposition 2 was the budget trailer language about if the state then puts into the rainy day fund, then districts are going to be limited with their reserves to twice the amount of their reserve for economic uncertainty, depending upon the size of the district. Assuming that Proposition 2 pass, and CSBA is working very hard to get that trailer bill repealed, assuming that it passed, how do you see that implement or affecting negotiations?
It becomes very problematic because if you look back over our very difficult economy over the last few years, the districts that had healthy reserves are the districts that stayed solvent, the districts that didn't have to balance their budget on the backs of staff and teachers as much. So if the reserves are limited and spent down, it's going to make negotiations very difficult. When I have a district that has healthy reserves, they have so many more options. They can look at one-time options, they could look at covering potential litigation that might occur, they can weather difficult experiences that they may have, and without that, it's just going to make it much more difficult, I think, for negotiations and for districts as a whole.
I agree with Karen, but I think the soundbite here is it's still one-time money. And so, that is the education piece that we as districts have to do. The idea of the rainy day fund is already making its way to the table. You have union bargaining teams saying you cannot have more than X amount of reserve, and then it's up to the district team to educate them and say, look, that hasn't happened, and once it happens, there are many conditions that have to be fulfilled before you get to that point. But you need to get ahead of that communications piece, and I think you also have to talk about that even though we may have a 21% reserve, that is one-time monies. It's not going to go to fund something ongoing.
And the reserves have always been part of, they've always been part of negotiations, always been part of discussions and priorities. But even if that happens, and there is a requirement that the board spend a portion or a percentage of that reserve, Still, with LCAP identifying all the different priorities and all the different targeted needs that a district actually has, I still think that there are going to be other choices that are going to be made other than just, across the board salary schedule increases, which again, you should not be using with one-time money. So.
And how about local accountability? I mean, the fact that this is local control funding formula, yet you're going to tell us to get our reserves down to a certain amount.
That was the difficult piece.
Yeah.
So we're halfway in, and I waited. I was very patient. I wanted to get your feedback and your experience with respect to the compensation piece. And the local control funding formula came out with a base grant. And then we know, based on unduplicated pupil counts, we have supplemental grants and concentration grants. How has that worked out at the table in terms of identifying those three streams of dollars for compensation increases, whether they're a one-time or ongoing compensation impacts to the budget?
So the base grant is similar to what our old revenue limit model was, and that can be used for across-the-board increases, even though it's been greatly diminished by a number of these other factors that we've already talked about. I think the more nuanced conversation has to do with the supplemental and concentration, because that money is going to need to go to the improvement of student achievement, the pupils who are targeted. And so when we talk about that money in negotiations, it's really more looking at the effects and impacts of programmatic changes, and those could be additional staffing. There are positions that districts that I work with are hiring now that they've never had before. The creation of new positions like mental health professionals, parent outreach staff members. So what does that look like? What do their job descriptions look like? How are they compensated? You're looking at things like more collaboration time so that teachers can meet, develop materials to implement Common Core. Those are the kinds of monies will be spent on. So when we're negotiating at across-the-board salary increases for, we're not looking to use supplemental and concentration for across-the-board increases. We're looking at how do we improve program and services to kids, and if there's an impact on our bargaining units, negotiate those impacts.
Well, and we're not wanting to use the supplemental concentration for across-the-board salary schedule increases, but I think we were beginning to hear it last year, and we're going to hear it more so this year, that there will be some unions that want to use those dollars.
Aren't there incredible demands out there now?
That's what's happening.
But I think, so I have a different perspective. I agree with what both John and Karen are saying, but if you are one of those districts where the unduplicated pupil count is 70, 80% running throughout the district,
True.
not at a specific school site, then an argument can be made that in order to implement certain kinds of programs, and if you're going to be associating a stipend with it, that could be applied unit-wide. I think it's easier to make the argument that we are not going to be using supplemental and concentration grant monies if you have pockets of students, that they are not district-wide every which way. I have a district that has almost 85% of their entire student population as the unduplicated pupil count. And so any kind of programmatic changes that they are making to the curriculum that does impact the bargaining unit is going to be realized, that salary increase is going to be realized across the board. So I think we have to be cognizant that CTA and AFT's position is it should be applied universally, but I don't agree with that.
And yeah, universally. I mean, we talked about that comparison, and how does that happen? And if as you have a district with an 85% unduplicated student count, how does that then going to measure up against those with 35 to 40%?
And I think the risk is in doing that, and I think in some districts where the unduplicated count is 80, 100% of the student population, it's a different situation. But in any situation, I think ultimately when you look back, if students are performing at greater levels, if they have more access to A through G courses, if they're graduating in higher numbers, if their attendance goes up in those schools because the teachers are better compensated, I think that's probably fine. The concern is if you apply across the board increases using supplemental and concentration, and there is no bang for the buck, there is no return on that investment, those districts are going to be in trouble when the advocacy groups and all the community members who have been actively engaged in the process don't see the results.
But it's going to be very case by case and district specific. And I totally agree, Namita. If you have a district with where it's 85%, there might be a very good argument for using some of those dollars for across the board salary schedule increases for all unit members. But I think in most cases, I think if the district and the board stick with, what do our students need? What are the needs of these particular students in all these different areas? You're going to have, targeted proposals that don't necessarily correlate into something across the board. The base grant, absolutely. That's something that should be talked about at the bargaining table. But as we get to supplemental and concentration, it's an entirely different ballgame. And that's the kind of dialogue I think that we're beginning to have.
Very nuanced.
Yeah.
So let's go from a subject that we know is the subject of negotiation impact by the decision. We have Common Core out there. We have LCAP goals that hit into the instruction area, hit into test results. How are you dealing with, are you getting many requests to consult versus to bargain some of the issues that have now come out of the LCAPs? And how are you dealing with, for our board members, it might be really new to them, they understand bargaining, but what about these requests to consult and have dialogue on some of the goals and objectives of LCAPs? How are you dealing with those?
I think a couple of things have come up most recently. One is a desire to have an agreement that specifies what consult means.
Okay.
So in other words, if you have a committee working on increasing parental engagement, increasing community involvement, bargaining units want to be part of that committee deciding how to design that outreach program. That's new. And they're healthy conversations, they're great conversations. The other thing that's new is, and I think some of it might come from just the worry of implementing change in terms of Common Core. I hear a lot, we really need more time together as teachers. We really need to spend more time collaborating. We really need to have some sort of a database of materials and new curriculum to implement Common Core. We have people who are individually creating a lot of new materials and things that we can share, but we don't have a way of spreading that across the district. So I hear more interest in professional development opportunities, collaboration opportunities, and just to concretize how they're actually involved in the consult process and the engagement process in developing the LCAP.
When the duty to consult, actually, I think districts and unions do their best work when they're away from sort of formal negotiations, and they have the opportunity actually to work together in not necessarily negotiations, but true consultation and collaboration. So when all of this first started and we were getting a lot of demands to consult, I think we were sort of going through that that sort of trying to figure out what the contours of the duty to consult actually are. And it seemed in some cases that it was actually an intention to actually negotiate LCFF or negotiate the LCAP. Benefit of the year to better understand what the advantages and benefits of consultation can actually be. And I think that's another area where we're going to continue to evolve. But school boards should welcome that involvement. And I think the districts and the unions that will really succeed maximize their communication with one another and see each other as partners in the best sense while being faithful to, there's some things that aren't negotiable, there's some things that are, and there's some things that we welcome the opportunity to consult on. Which doesn't mean we necessarily have to we don't reach agreement on those items where we have to consult. That's not expected or required. But at least we need to have a meaningful dialogue and discussion.
And I agree with John, and I'll also
This
add.
is the fourth time.
Okay.
It's now recorded.
Yeah.
I will also add that the consultation protocol that Karen is referring to is making its way around districts. What I find most interesting is it has a clause at the bottom that if the parties don't reach agreement on consultation, that it will be subject to the grievance process. So that is not what you want to sign.
Right.
You really want to have a consultation process that is organic and truly collaborative. If you're a district that has had a consultation process without actually outlining a consultation process, I say to you, it's not in your culture, you don't need to have that. But if you have a lot of pushback from the unions that are talking about formalizing a consultation process, then make sure that it's not binding you to something that you wouldn't necessarily need to be binded to.
What are you preparing yourselves for this year in terms of subjects of negotiation that you may not have been at tables prior to this, the LCFF? I mean, you've spoken of a few earlier today in terms of some planning time, staff development, you know, school day. What else do you see now or maybe in the future are going to, besides the compensatory issues, are really going to take some time and effort at your tables?
One is interesting is the higher demand on counseling and mental health services and supports. I find that we're putting more pressure on our students to achieve, and with that pressure, there's more need for the social emotional aspect. So I'm hearing at the table more and more often, we'd like to bring our counselors in, we'd like to bring our school nurses in. Let's have a conversation about what their demands are, what their duties are now that the expectations are so much higher for students. So that's new.
And is that connected to some of the outcomes that in the LCAPs that have been put together?
Yes, exactly, exactly. With increased expectations for students to be in multiple AP classes, to satisfy the A through G requirements, to go to college. To catch the students that have been disadvantaged in the past, there needs to be a social emotional aspect, not just for the student, but oftentimes for the families as well. So that's new in my experience. It's always been a little bit out there, what's the ratio of counselors to students, but more so now the social emotional impacts.
For me, it's workload. Workload.
Yes,
It's being iterated in different ways, whether it's collaboration time, common planning time, how it falls through, whether it's implementation of some kind of a software program that is going to require you to have everything entered electronically, whether it's the student information system that you may have entered in place and you are now notifying the parents more frequently. It's the kind of students we are seeing, it's the kind of work that we are doing. That is the conversation at the table. We're not being compensated enough. The job has evolved, the work has gotten more, and how are you going to compensate us for it?
And class size is going to be a big issue too. There might be a school site average, but there might be in some of the targeted areas we might want to have a significantly lower class size or want to work out special arrangements, certain stipends for certain work that's being actually performed based on your LCAP. So all of these things I think are going to be in play, and we know that the LCAP doesn't trump the collective bargaining agreement. If there are items or issues that are identified in the LCAP and they raise something that's negotiable, then we're going to have to deal with those at the table. But we're going to have to be open to sort of hear these out and figure out some good options to move forward with.
Well, let's talk about the grade span adjustment. And I mentioned in my opening remarks that you had helped us with a legal guidance going out next week on the grade span adjustment. One of the options, it's about a 10% to 11% bump for districts that qualified, and I understand if they automatically qualify, they could get taken away later if they then don't hit their marks. And there's different ways to hit the marks in terms of an average class size K through 3. But it's also a collective bargaining agreement in that language. So it enables you then to hit the grade span adjustment for years to come. Have you had negotiations specific as to that?
It's an issue that came up last year. I think it's going to be an issue that continues to come up. You can have a collectively bargained alternative so long as it's school site specific, and you can have that. The law itself and the regulations speak in more general terms. One of the concerns we have, though, is whether you can actually rely on an existing agreement that has such an alternative. Let's say you have a class size maximum, that let's say it sets the maximum at K3 at 30 or 28, something significantly above 24 to 1. Should you be able to rely on that contract, whether it was negotiated many years ago or after LCFF? What we're seeing based on information that CDE has put out, information that we've seen in actually the latest audit guide, is actually that auditors are going to be looking for something prospective, something that was agreed to pursuant to LCFF that says, yes, we've agreed to a negotiated alternative, which I actually think goes beyond actually what the law expressly states, and that's actually regrettable. But there will be some districts that actually reach an agreement and they have left their class size language untouched. And that class size language does have a 30-to-1 max or something else that would meet the requirements of collectively negotiated. And some will choose actually to rely on that without necessarily an MOU or a letter. I'm a little concerned about whether that will pass the auditor's scrutiny, but that's the area where I think districts are going to have to work closely with legal counsel and the unions to make sure that they have a clear understanding as to what they agreed to.
So that's scenario one. There is the other scenario where districts are wanting to go down to 24-to-1 at K3, and they may have a priority as outlined in the LCAP that they want to be at 24 in kindergarten right away. And so then the dance becomes with the union whether you want to have a graded movement to that 24-to-1, because then there is more money available. You know, if you, so there are many iterations of class size. Remember, class size is one of those battle cries that school boards are going to lose every time if you insist on a larger class. You know, so you have to be very careful, but it comes in various iterations in different places. And right or wrong, that's where many of the battles in elementary schools are around.
And isn't ironic, and John mentioned it earlier, declining enrollment. The impact of declining enrollment is you have less teachers and you have higher class size and to respond to declining enrollment, where you would intuitively think, well, that there's less students, then the class sizes should be smaller, but declining enrollment really creates the opposite. So have you had experience with bargaining the grade span adjustment?
Yes, one of the interesting aspects of it is a couple of the groups that I've negotiated with have looked for the alternate agreement as an opportunity to negotiate some sort of additional support for teachers. So for example, if we're going to agree to keep class sizes at 30-to-1 or 28-to-1, in exchange for that, we would like some additional supports for the teachers that have those class sizes at the higher levels. We'll give you the alternate agreement with the higher number, but in exchange for that, we would like some compensation, or we'd like some additional instructional assistance support. Those are the kinds of things that I'm seeing. The other thing is, I think as we become more familiar with LCFF and LCAP and the grade span adjustment rules in order to maintain that 10%, there's a desire not to lock us in too long with an agreement. So most of the agreements have been 1-year or 2-year agreements on class size. It hasn't been we're going to change it prospectively from here on out. It's only been a willingness to pilot something or to have it only be a couple of years.
And if we're agreeing to essentially on the class size in exchange for something else, I think we need to make sure that those things that we're doing in exchange aren't ongoing. If we're only doing the agreement for a year or two.
Exactly.
So as part of the LCAP process, one of the goals and what districts and county offices will be measured on is parent engagement, stakeholder involvement. How have you found that in your discussions with your school board members who are used to, in our negotiations, very used to the bargaining representatives, the bargaining groups, and being the seat at the table? How have you incorporated that maybe in some of your discussions when you've gone to get authority this year? How have you incorporated this notion of other stakeholders now putting pressure on these same board members via the LCAP process?
Well, obviously other stakeholders are going to be very interested in what's happening at the bargaining table. And traditionally, or in many cases, there's not a lot of publicity, or a lot of people in the community don't know what's happening at the table.
Do they know, is ERA, I mean, is that getting out that LCAPs are done, but part of LCAPs may have to be bargained later in order to...
They will have to be bargained later, and I think all of those other stakeholder groups are going to want to know even more so what's happening during negotiations. And school boards and districts have every right to communicate about what's happening at the table, because all those different to be saying, hey, not only communicating about budget and communicating about priorities, but I think also communicating about the status of negotiations, whether it's newsletters or information online, so that people know and the community knows that the things that the district is putting forward and our proposals and how we respond to proposals from the union are actually consistent with that LCAP or previously articulated district board priorities.
So could you see a time where when we do our initial proposals and we sunshine those proposals of both bargaining units, that besides representatives in the audience, stakeholders will be in the audience for those meetings where our proposals are sunshined? Do you see that as a time?
I can certainly see that. I mean, those members right now get the board packet that has the sunshine materials anyways. I just think that this is the right time to start having those conversations as part of the study session. You have boards that are having elections, you're going to have new members coming on. This is like the perfect time to sit down, reanalyze how our LCAP was received by the County Office of Ed. What did we do right? What did we do wrong? How do we go about making sure that we reach out to more people? I just think many boards that I work with are being very innovative about how they're holding that forum, whether it's old-fashioned paper method, whether it's Skyped meetings, whether it's town halls or community forums. They just have to get creative, but the time is right given the fact that you have November elections coming close.
The other aspect to all of this is that there's language in the LCFF law that says that nothing in the LCAP can infringe upon collectively bargained agreements. And so another thing that comes up and that I have to advise boards about is just because it's in the LCAP, if it has negotiable effects, doesn't mean it can be implemented until we work through that process. So in terms of timing, we've got the budgets adopted, the LCAP's adopted, the negotiation, ideal situation is happening on a parallel path on some of the items that are anticipated to be in the plan. But if they haven't and we don't have an agreement, we can't implement some aspects of the plan. So that's challenging for school boards to understand. I think there's a frustration. We've gone out, we've done all that we can in terms of community engagement. Karen, are you saying we can't implement this action that's going to be wonderful for kids? And I say, well, I'm not saying you can't. I'm saying that there's a process and we have to work with the bargaining units so that we can implement this. And issues may come up, and then we'll talk about it some more. But it's important to keep that in mind. I think people forget about that.
And between what, AB 1611 and the Santa Clara PERB decision from the 2013,
And just a little summary of both.
Well, essentially, 1611 was just enacted. It'll be effective this coming year, and it essentially says that any change made to, the reasonable notice must be provided to, by the employer, to the union, of any change that's within scope of representation. Santa Clara decision also from PERB broadened what we traditionally knew as being the duty to negotiate effects. So I think we're seeing sort of this proliferation of issues that could be negotiable.
That's right.
And I think the unions are well aware of that. So based on what Karen just said, that LCAP doesn't trump the collective bargaining agreement. Anything that we want to move forward on the LCAP, if it's negotiable, we have to negotiate. This is going to be part of the discussion with boards that, yes, you have this LCAP, but we need to be really mindful of what our obligations are to the union, and what's negotiable is actually expanding these days.
And that's where the collaboration between the
Yep.
unions and the district becomes so critical. I mean, we saw last year there were many districts that went out and did their parent and community outreach before talking to their teachers or before having this meeting with their teachers. I'm not saying that you have to negotiate everything up front, but the idea to have shared partnership in the district priorities that you are proposing or aiming towards, I think it helps you out tremendously in the long run as you think about coming to the place where you need to negotiate certain work conditions.
And so for our board members, we talked about the duty to consult, which is really an engagement outside of the requirements that we go through in our bargaining, in the bargaining context with ERA. We've talked just now about our duty to negotiate decisions and effects bargaining. And they're all kind of getting together. We want to keep our consult on this side, but effects and decisional bargaining are all kind of merging together, as John pointed out. And where I think of effects bargaining, I think of a lot of it in terms of when there might be a reduction in force with our classified staff and how we would have to do effects bargaining before we could, take and sign off on that reduction. So it leads me to the question about our classified bargaining tables. We've spent today talking about primarily our certificated tables. What's going on the classified side?
Well, classified negotiations have become very interesting. My own observation is that there are a lot of new labor reps at CSEA, and some come with a good wealth of knowledge and experience, others less so. So we're sort of navigating our way through and dealing with a lot of new labor reps. But some of the toughest negotiations actually are at the classified tables. Things have really stepped up. And I don't know whether it's a perception that somehow LCFF and LCAP are more focused on the certificated side, and it's trying to get more focus on their particular issues. But it has become more contentious. On the other hand, there are a lot of tables that I work with on the classified side where the relations are good, and we continue to make progress regardless of whether it's LCFF or LCAP.
I think one of the big issues that I'm seeing at classified tables is new positions. So the idea of reaching out to members of the community, community liaison positions, how that is now impacting current positions that the unit may have had. So if they had translators that normally dealt with parents and they were a specific job category, a specific job description, and now you're bringing in all these new classifications under the LCFF, the LCAP, where you are engaging in parent outreach, how are those two positions going to flush? If they are in the same unit, great, your work is a little easier, but if they happen to be across different classified units, your work is cut out for you. So that's one area. The other area that I'm seeing a lot of movement on is around the idea of instructional aids in the classroom. Because you have LCAP plans that are talking about more support in the classrooms, you are actually looking at districts that are bringing in para-educators or instructional aides in a general education classroom. So how is that going to work in terms of moving people around if somebody is out, or asking a general ed para to be a special ed para in case somebody is out for the day? So those are the day-to-day bargaining issues that we are seeing coming out of LCFF. I think the other piece that John just mentioned, which is the newness of the labor reps, that's also exacerbated by CSEA's 610 process, because it seems like local unions, local bargaining locals are deferring to the CSEA organization. Right or wrong, that's their protocol now, but what's happening is it's putting a third party at the table.
Without being there.
Without being there, which sometimes complicates relationships and it complicates the issues.
Karen?
Right. I agree with Namita and John. I think the interesting thing is there's a full spectrum of involvement in the LCAP process. I have one district where the classified units, there's multiple, AFSCME, SCIU, Teamsters, other groups, have been extremely involved, attend every parent engagement meeting, every community forum, and have used those opportunities to advocate for classified positions, bilingual educators, bilingual paraeducators, and other types of supports, library programs. And then I have other groups who have taken very many steps back and haven't been involved at all and aren't knowledgeable about the process. With those classified groups, I think with all bargaining partners, I think the importance of the education of the process can't be overemphasized. I think there are going to always be those at the top leadership levels of bargaining groups who go to the trainings, read the materials put out by their leadership, and then there's going to be a great majority of them who are at the table who really don't know what this is all about. And so the time spent on reviewing the new formulas, reviewing the process of developing the LCAP, why it's important to student achievement, I think that education process is more important than ever, especially with the classified groups.
And really the classified groups are equal stakeholders in the whole process. And I think we saw it last year, and I think we're going to see it again this year. I think there's a real hunger or thirst for professional development from the classified units as well, wanting to be part of that. And of course, majorities of their membership, or a significant portion of their members, are in the classroom directly with kids, and they need to be part of that as well.
Well, I would like to thank Namita and John and Karen today for being here. I think for those of you that have been with us the entire hour have appreciated the depth of this conversation and really the experience with this issue that our three attorneys bring to us today. The LCFF is as dynamic of a process as the conversation was today. We've got a new template to work with this year. We've got an evaluation rubric that will be completed by the state in October of 2015. This is an update year, so what you did last year is going to be on full display this year, and you'll have to make decisions. And so my guess is we'll be right back here next year in October, as we were last year, to talk about bargaining. So I'd like to thank our viewers for spending this last hour with us, and especially those of you who contributed questions. Thank you to our presenters for your valuable insight, as well as your firm's ongoing partnership with CSBA as business affiliates. Finally, this production would not be possible without the hard work of CSBA's backstage crew, our communications, IT, and legal teams. If you missed any part of this webcast or would like to tell a colleague about it, it will be available on our website on Friday at www.csba.org. You may contact our presenters via their email addresses that will be posted once the webcast is made available on Friday. They would be happy to work with your district or county office directly on the issues we discussed here today. Momentarily, you'll be receiving a survey via email. CSBA would appreciate your feedback on our presentation, as well as topic suggestions for future webcast series. So please make sure to take a few minutes to let us know how we did. Thank you again for joining us today. We'll be back on Wednesday, October 22nd, discussing the Brown Act and open meeting law.